Can I ask one simple question?
Sure.
I'm just trying to ask. I watched the video
Uh-huh.
and the case started, and I was the one that was sitting with it. So,
So that's what a jury's for. If you don't think you're guilty of what they're said, that then
even I can't assault you if I'm already.
I don't need to know that. That's what a jury's for.
Yes.
Either you accept the plea agreement because you're guilty, and if you watch the information with your attorney, then you've seen everything the state has and they'll present, and we can let a jury decide. I just want to make sure you understand what the consequences are and what your options are. Do you understand all of that?
Yes.
You're watching Court Beyond, the channel that takes you inside real courtrooms where justice unfolds exactly as it happens. In today's session, we're in front of Judge Raquel West, a respected and decisive figure known for her calm authority and fairness. In this case, Traylin Martin stands accused of obstruction or retaliation, a third-degree felony that could mean up to 10 years in prison. The state offers a 2-year plea deal, but Martin claims he was the one assaulted. As the discussion unfolds, Judge West keeps order, cutting through confusion and reminding everyone of the weight that justice carries in her courtroom. Now, step inside and witness how Judge Raquel West handles this tense exchange.
Good morning, sir.
Good morning.
Are you Traylin Martin?
Yes, ma'am.
And Mr. Martin, in cause number 25 DCCR 0270, you're charged with the third-degree felony offense of obstruction or retaliation from January 29th of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And what is the offer that's been made?
2-year TDC, Judge.
And so the state has offered, if you want to enter a plea of guilty, a 2-year term in prison, which is the minimum. You have every right to reject that and have your case set for trial. But I want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial, or do you want to take that offer?
Can I ask one simple question?
Sure.
I'm just trying to ask. I watched the video
Uh-huh.
and the case started, and I was the one that was sitting with it.
So that's what a jury's for. If you don't think you're guilty of what they're said, that then
even I can't assault you if I'm already.
I don't need to know that. That's what a jury's for.
Yes.
Either you accept the plea agreement because you're guilty, and if you watch the information with your attorney, then you've seen everything the state has and they'll present, and we can let a jury decide. I just want to make sure you understand what the consequences are and what your options are. Do you understand all of that?
Yes, ma'am.
So
And just for the record, I've explained this to him. I've shown him several different videos. Some of them are more relevant than others, and he indicates some things that there may be other videos out there that I don't know about. They're not there as far as discovery. He's indicated he wanted to hire Marsha Norman, and I told him you can reject it. If you're not guilty, then don't plead guilty and reject it. And if you can still hire Marsha in the meantime.
Mr. Nichols, is there any other discovery that you anticipate?
I didn't see any in the file from Ms. Volcano, anything else, Your Honor.
Okay.
I know she made the offer. I know that he had got a reduction on the same charge a year ago. So I don't see any reason the offer would change. I did ask for probation this morning. I did not change it.
Okay. So, Mr. Martin, if you don't want to accept that offer and you want to plead not guilty, I need you to sign the plea bargain rejection so that I know that you and I have had this conversation.
Yes, ma'am. I just want to ask. I've been trying to get a job and work to see if I can just see if it'll help me out with my time as a trustee.
Okay. That none of that matters right now, okay? Because here's what we're not going to do. We're not going to put your case on the trial docket so that you think you can get some time under your belt, and then you're going to plead guilty later, because after today, I won't accept this plea agreement. We don't put cases on the trial docket just to buy some time. Either you did it or you didn't do it. And if you didn't do it, then you can sign that and we'll get a jury to decide. But I don't want you to think you're going to come back in here later and say, oh, I want to take that deal, because it's not going to happen.
Um,
All right.
am I eligible for parole?
I don't know when you're eligible for parole. I don't know how much time you have.
You never had to do this. That's why I'm asking.
I know. And that's why Mr. Parker's, nobody knows when for sure you would become eligible for parole or if you would make your parole. We don't know that because that depends on other people, not us. I don't make that decision. Your attorney can't tell you that. He doesn't know. It just depends on.
I've explained to him what how much time, based on what he's told me he has, and how much time I think he'll have to do before he's eligible. But again, I told him I can't guarantee that. But again, if you're not guilty, then don't sign. You put reject.
So it sounds like Mr. Parker's explained all this to you. So either you don't want to take the deal, you are not guilty, and let's go to trial, or you plead guilty and
I'm gonna go ahead on the sign.
sign what?
I'm not guilty.
You can't say you're not guilty and then sign for time. It doesn't work that way. Because what happens, for obstruction, it's not assault on an officer. It's obstruction or retaliation, which is different. And there are different elements of that offense than assault on a police officer. So Mr. Parker has gone over that with you. If you want him to explain it again, what specifically that is before, but you cannot come up here and say I'm guilty of something, or I'm not guilty, but I want to take the deal. If you didn't do it, you go to trial. If you did it,
I want to go to trial.
okay, sign that for me, rejecting that plea offer then.
Okay, we're at.
Look, sir, pay attention. Sign that.
Okay, I'm waiting on that.
There we go.
Yeah, I mean, you got a hospital. Yeah, and I got evidence for free will.
So real quick, hold on before you go back. Mr. Parker has been appointed to represent you. And with your permission, he handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes,
All right. So I'm going to appoint a new attorney today. They'll be out to see you very soon. Huh?
Can I pick one or y'all?
No, you're going to get whoever's next on our list. If you have whoever's next on the list.
Hire whoever you want.
You can hire, if you have the funds to hire someone or your family wants to hire someone, they can do that. Otherwise, I'm appointing someone today so they can start getting ready. Okay.
Yes, ma'am.
All right. You can go back with the bailiff.
Following the previous case, we move to another matter involving Devont Anderson, appearing for a motion to revoke his probation. Anderson was originally placed on deferred probation for 2 second-degree felony offenses: sexual assault of a child and indecency with a child by contact. The probation department now alleges multiple violations: missed reports, failed drug tests, and incomplete treatment requirements. As the court reviews each count, Judge West maintains her steady and precise approach, ensuring the process remains fair, structured, and within the bounds of justice.
Good morning. Are you Devont Anderson? And Mr. Anderson, in cause number 23 DCCR 0288, there's a motion to revoke probation filed, and same in 23 DCCR 0290. And what is the announcement?
Your Honor, we don't have an agreement. I believe it's probably best to go through the motion.
Okay. Give me just a second to get this. Can you print the second one?
I don't know if I have the amended.
I don't see an amended one.
I don't know. Okay. I thought we said well together. They go weeks ago. Okay. Okay. I'm good.
Give me just a second to get them both pulled up, printed out. Mr. Anderson, while we're waiting on those to print out, would you best you can raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right.
Thank you. Same violation in each case.
All right, thanks.
Yeah. Yeah.
All right, and will your client waive the formal reading of the motions in each case? Mr. Anderson, in cause number 23 DCCR 0288, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 24th of 2023 for the second-degree felony offense of sexual assault of a child, and that was a 7-year deferred probation. Is that correct? And in cause number 23 DCCR 0290, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation that same date, October 24th of 2023, for indecency with a child by sexual contact, a second-degree felony, and that was also a 7-year deferred probation. Is that correct? Each of these motions allege that you violated your probations. Count 1 in each motion alleges that you failed to report to the Jefferson County Probation Department by mail or online for the months of November and December of 2023, and then January, February, March, April, May, and August of 2024. And is that true or not true? Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 in each case alleges that you failed to provide verification of performing your community service hours. Is that true or not true? It just says that you didn't give proof that you did your community service hours that were required. Did you do that?
I did some.
Okay, we'll just put a not true on that one. Count 4 alleges in each case that you failed to complete a substance abuse assessment and follow any recommended treatment plan. Is that true or not true? Count 5 in each case alleges that you provided urine samples April 23rd of 2024, August 13th of 2024, September 19th of 2024, November 25th of 2024, and December 5th of 2024, and then January 30th of 2025 that all tested positive for marijuana. And is that true or not true? Count 6 alleged that you failed to successfully complete an approved sex offender treatment program. Is that true or not true? Says that you were unsuccessfully discharged December 6th of 2024. Okay. Count 7 in each case alleged that you failed to submit to the polygraph examination as required December 6th of 2024. Is that true or not true? Count 8 in each case alleges that you failed to not enter a sexually oriented premises in that you admitted to your Harris County officer that you went into an adult bookstore. Is that true or not true? I'm sorry, not true. Count 9 in each case alleges that you failed to not use any online services, social media, or anything like that unless approved, in that you admitted to your Harris County officer that you accessed the internet without monitoring software. And is that true or not true? Count 8 alleges in each case that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true in each case to counts 1, 2, 4, 5, 6, 7, 9? Would you, Mr. Hoffpower, any objection to that?
Repeat that, Judge?
That number,
Oh, no.
it should be number 10, and
Okay.
it says number 8. Any objection to him orally amending that? All right, so that changed that. In each case. Okay, so did you enter your pleas of true to those counts freely and voluntarily? And because those counts are actually true. All right, I'm going to find in each of your cases that you entered your pleas of true to counts 1, 2, 4, 5, 6, 7, 9, and 10 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for a sentencing hearing so that I can get an updated pre-sentence report done, or an updated report done by the probation department. Your attorney will be able to present any evidence on your behalf, and so will the state, and we will come back for a hearing at a later date. All right, you can go back with the bailiff.
From Traylin Martin's decision to stand trial to Devont Anderson's probation violations, every case reflects the weight of personal choice and the discipline of the law. Thank you for watching Court Beyond, where real courtroom moments unfold exactly as they happen. Subscribe for more real cases and insights from Judge Raquel West's Courtroom.